power of attorney is a legal document appointing a person to manage your financial and legal affairs during your lifetime. The person you appoint is then known as the attorney. In order to make a valid power of attorney, you must be over 18 years and have legal capacity to understand the nature and effect of the appointment. Yes, there are two types of power of attorneys: general power of attorney and enduring power of attorney. Each of these legal documents play separate and distinct roles in the estate planning process. It is possible to have both a general and enduring power of attorney at the same time. The type of power of attorney depends on your circumstances. A general power of attorney is a legal document which you can use to appoint a person to make decisions about your property and financial affairs prior to loss of mental capacity for specified periods or functions. Because of this, many people will appoint a general attorney if they are travelling overseas or if they would like to appoint someone for a specific role, like executing a contract on their behalf during a specific period. An enduring power of attorney is a legal document which you can use to appoint a person to make decisions about your property or financial affairs if you lose mental capacity. This is the most essential document of the two forms of attorneys. This is your fail-safe and ensures that if you lose capacity, your finances will be taken care of by your attorney until either you regain capacity or your passing. The first step in this process is to make an appointment with us to discuss your needs. We will, prior to your appointment, send you information to complete to assist you to consider relevant issues prior to your meeting. Questions we may ask you include: who would you like to appoint as your attorney? Do you want to appoint more than one attorney? And if so, do you want them to be appointed jointly or solely? What are their full names, address and occupation? In the circumstances where they cannot be your attorney, who do you want to be your alternate attorney? When do you want the attorney to be effective from? A specified time frame? For a specific event? Once you lose capacity? Do you have a spouse or minor children? If so, do you want provision for them made in your power of attorney? Do you want to limit your power of attorney? An attorney can have enormous power over your financial affairs. You should choose an attorney whom you trust and who will manage your finances in a responsible way. If your financial affairs are complicated, you should appoint an attorney who has the skills to deal with complex financial arrangements. You may wish to appoint a family member or a close friend as your attorney. You can also appoint a public trustee or a trustee company, but fees will apply. You can also appoint more than one person to act. And you should also appoint an alternate or a backup attorney in circumstances where your first choice cannot act. We can help you work through any questions you may have about who to appoint. This depends on the type of power of attorney and the provisions within the power of attorney. With a general power of attorney, this is usually limited to a specified period of time, for example, while you are away. With an enduring power of attorney, this usually comes into effect once you have lost capacity and ends either upon regaining capacity, if you do, or on your death. This is specified in the drafting of your document, and we can discuss this with you further in your appointment. Please contact us to appoint your power of attorney. Our experienced solicitors can discuss which of the two types of attorneys you require and draft the necessary documents. If you would like more information, please contact us.